Thank you, everyone. Good morning, good afternoon, and good evening, wherever you may be. Thank you for joining this ACRL Leadership Discussion Group. My name is Ray Pan. I am the convener of the ACRL Leadership Discussion Group under the Association of College and Research Libraries. I'm also the first-year student success librarian at Fresno State, and it is my honor to really host and moderate this panel of our speakers today, and really to give you an opportunity to hear more from their thoughts and perspectives and expertise in what free speech means today on campuses. So before I get started, if you have any questions and so forth, you can type in the chat and we'll take them at the very end. This webinar will be in 3 different formats. We'll basically have them introduce and their topics, and then we'll move into several questions where they can identify and specify their responses, and then we'll have Q&A in general. Before we get started, for those who are the librarians coming in and who plan to go to ACRL, the ALA conference, you may know that there is an upcoming program on linked data. So please check it out if you will be going to New Orleans in June. And so without further ado, I'm going to introduce the speakers. And thank you again for agreeing to speak, and thank you all for coming. So our first speaker to the left is Dean Erwin Chemerinsky. He is the UC Berkeley School of Law Dean. He became the 13th Dean of Berkeley Law on July 1st, 2017, when he joined the faculty as the Jesse H. Chopper Distinguished Professor of Law. Prior to assuming this position from 2008 to 2017, he was the founding dean and distinguished professor of law and the Raymond Pride Professor of First Amendment Law at University of California, Irvine School of Law, with a joint appointment in political science. He is the author of many books, including Free Speech on Campus with Chancellor Howard Gilman of Irvine. Unfortunately, we received a message this morning that Chancellor Gilman cannot join us due to family emergency. So we send him positive thoughts from there. Our next speaker, Dr. Joan Del Fattore. She is the Professor Emeritus in English at University of Delaware. She writes about the choice of live single with emphasis on what's involved in handling a serious illness while living alone. Her previous publications include 3 books with Yale University Press and dozens of articles, mostly about free speech, and she holds a PhD in English and an MS in clinical psychology from Penn State University, and was a professor at the University of Delaware for more than 30 years. So first, we'll have them specifically talk about their works, their thoughts, and have them introduce the topic at hand and give some context, and then we'll move into a series of questions. So Joan?
I sound like those advertisements for Verizon. Can you hear me now?
Yes.
Good morning, good afternoon, good evening to everyone. My role on this panel is to lay the groundwork for the discussion by talking about what academic freedom means and how the concept of academic freedom evolved in American universities. As some of you may know, in the years leading up to World War I, faculty were routinely and easily fired either for what they taught in their classes or what they published or what they said as private citizens about matters of public concern. Those roles were not distinct because there really was no difference. In the language of the time, trustees and faculty had what was called a master-servant relationship, so that trustees could fire faculty for whatever reason. The distinction between whether you were acting as a professional or acting as a private citizen had no real meaning. Some faculty, led by Arthur Lovejoy and John Dewey, formed an organization called the American Association of University Professors specifically to address this issue. They argued, now remember this is the 19-teens, they argued that if American higher education was going to emerge into the world to take its place as a leader in higher education, we had to have a system in which experts in various fields could pursue research wherever it led could reach whatever conclusions made sense to them, and could argue it out with other experts, subject to the standards of the field and nothing else, to try to reach as close an approximation of the truth as possible. And it was important not only that professors have that ability, but also that they be seen to have it, so that the world would know that American higher education's research and teaching carried that kind of intellectual integrity and was not subject to the whims either of powerful forces or of the public. Let me read you what they said in 1915 in the Declaration of Principles on Academic Freedom and Academic Tenure. I warn you the language is sexist, but I did say it was 1915. Quote, "The lay public is under no compulsion to accept or to act upon the opinions of the scientific experts whom, through the universities, it employs. But it is highly needful, in the interest of society at large, that what purport to be the conclusions of men trained for and dedicated to the quest for truth shall in fact be the conclusions of such men, and not echoes of the opinions of the lay public or of the individuals who endow or manage universities," end quote. A very important element of this is that academic freedom was never meant to be a privilege for faculty or a status symbol for faculty. It was meant to be a means of achieving the public good and allowing universities to play the role in society that they were meant to play. The declaration continues on that point, quote, "To the degree that professional scholars in the formation and promulgation of their opinions are, or by the character of their tenure appear to be, subject to any motive other than their own scientific conscience and a desire for the respect of their fellow experts, to that degree, the university teaching profession is corrupted. Its proper influence upon public opinion is diminished and vitiated, and society at large fails to get from its scholars in an unadulterated form the peculiar and necessary service which it is the office of the professional scholar to furnish," end quote. Now, you may think that administrators would be hostile to this because it undercut their authority, but in fact, many university administrators agreed with the vision of American universities that depended upon the intellectual integrity and independence of experts in the various fields. By 1940, the AAUP had joined with the Association of American Colleges, which is now the Association of American Colleges and Universities, which represents university administrations. They came up with a joint statement of principles on academic freedom and tenure, which makes the same point. Quote, "Institutions of higher education are conducted for the common good and not to further the interest of either the individual teacher or the institution as a whole. The common good depends upon the free search for truth and its free exposition," end quote. That summarizes what is generally known as the professional standard of academic freedom. And for a long time, in most places, most of the time, it worked quite well. It did not always work. And when it failed to work, when administrations and individual faculty were unable to reach an in-house solution based on this, what they would have called at the time a gentleman's agreement, it would end up in the courts. And that's when things started getting interesting. Because, for one thing, the First Amendment, which guarantees individuals protection from interference with their speech by the government. It does not apply to private institutions. So private universities had to rely on their internal documents to protect academic freedom. It could not be referred meaningfully to the courts, or not referred to the courts in the same way that public universities could. It was accepted as a given pretty much from the beginning that the First Amendment does protect the right of individual faculty to speak as private citizens on their own time, in their own name, on matters of public concern. Where cases ended up in the courts was when there was disagreement between faculty and administration about a professor's teaching research, or other speech or actions within the university. The courts almost always upheld the administration. The reason wasn't because the courts disagreed about what academic freedom is. That is, they didn't disagree with the AAUP about what academic freedom is, but they disagreed about whose it is. According to the courts, academic freedom resides in the institution, which means, for practical purposes, the administration. This dates back largely to a McCarthy-era case called Sweezy versus New Hampshire. In a concurring opinion, Justice Frankfurter defined academic freedom as the university's right, quote, to determine for itself on academic grounds who may teach, what may be taught, how it shall be taught, and who may be admitted to study. But as a practical matter, by university, they generally meant administration. So in court cases where the faculty and administration were on the same side, as for instance, when a student challenged a university because of having been dismissed from a program, the faculty and administration were equally served. But when there was a clash between faculty and administration, even in situations where the professional standard of academic freedom would have upheld the faculty member, or at least would have guaranteed due process to the faculty member, the court would uphold the administration. In the court's view, the subject they were asked to consider was not what is the right answer in this situation, but who has the right to decide what the right answer is. Let me give you one example, and I've deliberately picked one that's the most extreme one I could find simply to make the point. What happened was it was at Tennessee State University, and an engineering professor named Nathu Parate gave a student a B because, among other things, the student had presented fraudulent medical excuses and had cheated on an exam. But the student had it in with the dean, who ordered the professor to change the grade to an A and to change his grading standards so that any other student who performed in the same way in the future would also get an A. The professor resisted. He tried writing notes that he was being coerced and so on, but eventually he gave in. He was an associate professor full-time, but he was not tenured. The situation went downhill from there. On the most striking occasion, the dean and the department chair came into the professor's class when he was teaching. The dean sat in the back of the room, shouted out objections to the professor, criticized his teaching in front of the students, leapt up to the blackboard to do the problem, grabbed the chalk out of the professor's hand, do the problem, ended up telling the professor that he could no longer teach this course, but was required to take it as a student. The professor did all this. He was nonetheless terminated when his contract ended. His contract was not renewed, and he sued. The court indicated, this was the U.S. Court of Appeals for the Sixth Circuit, the court indicated that the dean's behavior struck them as somewhat unusual. Nevertheless, they upheld the dean's right to fire the professor because the authority rested with the institution. Now, under the standard of professional academic freedom, there is no guarantee that the professor would have prevailed. As far as the record shows, we have no way of knowing, was this a dispute between these two people where the dean was being entirely unfair, or was this professor incompetent? We don't know that because the normal standards of academic freedom as a professional standard were not carried out. Very importantly, the court did not recognize the right of the faculty as a whole. The court found that the individual professor had no right simply to do whatever he wanted. There was no sense that the faculty as a whole had a role to play in determining who was fit to teach. That was the situation up until 2006, when a landmark Supreme Court case called Garcetti v. Ceballos sent, I think it's fair to say, some degree of shockwaves through the academic community. It actually shouldn't have. Prior to Garcetti, cases were decided in the way I just described, but there were relatively few of them. If you think about how many public universities there are and how many professors there are, the number of court cases was quite low, and many professors had no direct knowledge of any of them. So many professors had the mistaken belief that in a public university, as a constitutional right, as a matter of First Amendment law, their teaching and research were protected against interference by the institution. That had never been the case, but it was widely believed to be. Garcetti v. Ceballos broke that bubble. What happened in Garcetti, it was not originally actually about a university. Richard Ceballos was a deputy district attorney in Los Angeles County. And in the course of his duties, he reviewed an affidavit that had been sworn out by a deputy sheriff, and it had been used as the basis to get a search warrant. Ceballos concluded that the information in the affidavit was materially untrue, that the affidavit was significantly flawed, and therefore he recommended to his superiors that they drop the case. His superiors disagreed. They took it to court. Mr. Ceballos made his concerns known to the court. The court nonetheless upheld the search warrant, and of course, Mr. Ceballos accepted that result. But from that point on, his job became very difficult. He was moved to another location, and those of you who are more familiar than I am with Los Angeles traffic will understand that moving him to a place where he had a very long commute was a major job action. He was also reassigned to a less desirable position. He was denied a promotion, and he sued. He claimed that his speech, his evaluation of the deputy sheriff's affidavit, was protected under the First Amendment and the 14th. In a 5-4 decision written by Justice Anthony Kennedy, the Supreme Court ruled against Mr. Ceballos. They said that public employees enjoy First Amendment protection only for their speech as private citizens outside the scope of their jobs. But when they make statements associated with the duties that they're paid for, those employees, and this is a quote from the decision, quote, are not speaking as citizens for First Amendment purposes, and the Constitution does not insulate their communications from employer discipline, end quote. So by that standard, Ceballos' evaluation of the deputy sheriff's affidavit was something that his superiors could penalize. Again, going back to the language of the decision, it was, in the court's words, quote, the employer itself has commissioned, it was language that, quote, the employer itself has commissioned or created, end quote, and therefore the employer was entitled to regulate it. The court further said, quote, the fact that his duties sometimes required him to speak or write does not mean his supervisors were prohibited from evaluating his performance, end quote. And in context, performance meant not only things like quality or accuracy, but also content and viewpoint. So the ability of a public employee to discuss matters of public concern outside the scope of their jobs was protected and was considered to be sufficient exercise of their First Amendment rights. Now, 4 members of the court dissented from the majority decision. Justice Souter, in particular, wrote a dissent that was longer than the majority decision. All 4 of them said in different ways that this ruling goes too far. There certainly are times when government employers should be able to discipline or to regulate the speech of government employees in the course of their jobs. But as the dissenters pointed out, what if a government employee is charged with investigating to see if there's wrongdoing, and the government employee finds wrongdoing and can be fired for saying so? That particular consideration, which Justice Souter included in his dissent, turned out actually to happen. It was only a year later. There was a case in Dallas, Texas, where an athletic director noticed that the principal of the school, this was a high school, an athletic director noticed the principal of the school and the office manager were misappropriating funds. And he wrote a memo to the principal saying, here are the funds from the athletic budget that are being misappropriated and we need them, and could you please not do that? And he was then fired. Not long afterward, the principal and the office manager were suspended because through other means, the district had become aware of a range of financial irregularities. When this athletic director asked to be reinstated, the school officials did not wish to reinstate him, and it went to the Fifth Circuit Court of Appeals. The Fifth Circuit Court of Appeals wrote, quote, Garcetti held that the First Amendment does not protect expressions made pursuant to their official duties, end quote. Even if the speech is of great social importance, it is not protected by the First Amendment so long as it was made pursuant to the worker's official duties. And I'm sorry, there was an internal quote. The whole quote was, Garcetti said these expressions are not protected, and the Fifth Circuit added that is true even if the speech is of great social importance. So the athletic director was not rehired. The part of Justice Souter's dissent that was most relevant to this discussion, though, is the part where he raised the question, how does this decision apply to professors in public institutions? What Justice Souter said was, quote, "The ostensible domain beyond the pale of the First Amendment is spacious enough to include even the teaching of a public university professor. And I have to hope that today's majority does not mean to imperil First Amendment protection of academic freedom in public colleges and universities, whose teachers necessarily speak and write pursuant to official duties," end quote. Now, clearly, he had raised that point in discussions with the justices, and Justice Kennedy included a reply in the majority decision. Quote, "There is some argument that expression related to academic scholarship or classroom instruction implicates additional constitutional interests that are not fully accounted for by this court's customary employee speech jurisprudence. We need not, and for that reason do not, decide whether the analysis we conduct today would apply in the same manner to a case involving speech related to scholarship or teaching," end quote. That's generally known as the Garcetti reservation or the Garcetti caveat. So Garcetti says employees in public places, that is government employees, can be disciplined for their speech relevant to their jobs, except possibly university professors in their teaching and scholarship, but we're not saying one way or the other for sure right now. In the cases following Garcetti, which of course were very closely watched, that reservation was in some instances completely ignored. Or if it was acknowledged only to the extent that it would apply to teaching or scholarship. To give one quick example, because I don't want to run over time, there was a case in a university near me at Delaware State University, where a tenured full professor, Professor Gorham, was a department chair and was caught going into the computer and changing other professors' grades without their knowledge or consent to keep athletes eligible to play. He was found by a committee in the university to have done this on something like 45 occasions, including giving students passing grades for courses they did not take. A committee recommended that he be suspended for 2 years without pay. The president of the university, Alan Sessoms, asked the trustees to fire Professor Gorham. Professor Gorham sued. He said that the reason President Sessoms ignored the committee's recommendation of a suspension and went ahead to fire him was because he, Professor Gorham, had been very critical of President Sessoms. Case went to the Third Circuit Court of Appeals, which said, "We think that Professor Gorham was fired because he changed the students' grades, but even if he were fired for criticizing the president, that would still not be protected speech because under Garcetti, only speech that is classroom instruction or research is protected, and that would not cover things like what you say in a promotion and tenure committee meeting, what you say about a faculty hire, or what you say about university policy." We have now come essentially full circle. We're back where we were when I started with those years before 1915, with the perception that the best way to protect academic freedom in a meaningful way is through internal university documents such as collective bargaining agreements or faculty handbooks, as private universities have always done, rather than relying on the courts, which are not and do not claim to be in a position to make the kinds of judgments that need to be made about the quality of expert academic work. You might think that administrations would object to this, again, because it undercuts their authority, and I understand in a few cases that's happened. But especially in universities that seek to be competitive academically, administrations understand the point of the public good in the same way that the faculty does. At my own institution, we put in a post-Garcetti academic freedom policy that was really a model of meaningful interaction between an administration and a faculty union. I wrote a piece about it for Academe describing how that process happened. Everyone was on the same page in terms of what we were trying to achieve. And the administration added it was actually helpful to them because they wanted to have something in place that they could point to say, this is what we have agreed upon, it is binding, this is what we need to do. You may notice in everything I've said, I'm leaving out one very, very significant part of this discussion, which is the students. And the reason for that is that Dean Chemerinsky and Chancellor Gilman have written a massively good book about this, published recently by Yale University Press. So I'm happy to hand the discussion over to Dean Chemerinsky, who will carry the discussion on with respect to how this applies to students, both in terms of protecting their free speech and educating them about the need to respect the free speech of others. Thank you.
Thank you, Joan. Erwin, would you like to respond? Hi, Erwin. Are you over there? Hi, Erwin. Just testing again. Can you hear me?
I'm so sorry about that. My mic was unmuted, but there was a button that apparently needed to be pushed as well. It's a pleasure to be with you. Thank you so much for the kind words about Howard's in my book. Howard's wife had a health emergency. She's going to be fine, but that's why he couldn't be here today. And I'm delighted to talk for a few minutes for us. Issues of free speech on college campuses are nothing new. There have probably been issues with regard to student and faculty speech as long as there have been colleges and universities. But I also have the sense that things have changed to some extent now. Our mental image with regard to free speech on campus was so shaped by the free speech movement at the Berkeley campus in the mid-1960s. It was about students wanting to demonstrate on campus, claiming the right to speak about things unrelated to campus administration. Now, so often, it's outsiders who want to use the campus as their platform. It's controversial speakers like Milo Yiannopoulos or Richard Spencer or Ann Coulter. Often, it's outside groups that are coming to try to stop them from speaking. Also, there's been a shift in student attitudes with regard to speech. There have been a lot of studies that show that an increasing number of college students favor restrictions of offensive or hateful speech. A study by the Pew Research Institute found that 40% of undergraduates surveyed felt that there should be a restriction on offensive and hateful speech. Some of this, I think, stems from laudable instincts of students. This is the first generation to grow up from a young age being taught that bullying is wrong. They've internalized the message. Some of it, I think, reflects a lack of understanding of the history of free speech, how crucial freedom of expression is to achieve advancements in civil rights. I have increasingly found in talking about free speech that it's important to separate a discussion of what the law is from a conversation of what the law should be. There was a large panel, there's a panel at Berkeley on the campus in September in anticipation of the planned Free Speech Week, where it was said that Milo Yiannopoulos and Ann Coulter and Steve Bannon were going to come to speak. The Chancellor, Carol Christ, convened a forum that was very well attended. And early on, a faculty member spoke and said that the most important problem in our society is white supremacy. and Chancellor Chris should exclude any hateful speakers. There was resounding applause. In the question and answer period, a student eloquently and powerfully spoke up and said that she feels threatened when there's hateful speakers on campus. The chancellor should stand up for the students and exclude hateful speakers, no matter what the First Amendment requires, the court say. There was resounding applause. I then spoke as a member of the panel. I teach and write about First Amendment law. I litigate First Amendment cases. And I said, be clear, if the chancellor were to exclude these speakers, she would get sued and she would lose. The speakers would be able to have a First Amendment right to speak on campus. When Auburn excluded Richard Spencer, he and his supporters sued and won. The campus would have to pay the attorney's fees for the excluded speakers. The chancellor might be liable for money damages because she's violating clearly established law. The excluded speakers would present themselves as victims and martyrs. Nothing would be gained. They would get to speak anyway. No one applauded when I said that. Yet that's the current law. Let me quickly summarize for you the current law with regard to speech on campus. 3 points. First, all ideas and views can be expressed on a college campus. Period. The Supreme Court has been clear that even offensive, even deeply offensive ideas and views are protected by the First Amendment. I too am speaking just about public colleges and universities. The First Amendment applies only to the government. The story with regard to private universities is more complicated. In some states, there are state laws that protect student and faculty speech. California has a law called the Leonard Law that says that a private college university cannot punish speech that a public college university cannot punish because of the First Amendment. Also, private college universities have faculty and student handbooks that generally express a commitment to free speech. Courts have interpreted these as contracts with the faculty and students, respectively. But the bottom line is, when we're talking about free speech on campus, we are, with regard to the First Amendment, focusing on public college universities. With regard to private college universities, it would be law other than the First Amendment that applies here. I also want to echo what was said, that Garcetti versus Sabalas holds that there's no protection for the speech of government employees on the job and the scope of their duties. As was pointed out, Justice Souter, in a dissent, said that it's an open question whether it applies to college universities. I want to just add to the prior speaker, there is a Ninth Circuit case, Deemers versus Austin from 2013, that holds that Garcetti versus Sabalas does not apply to teaching and writing done by academics. So there's at least, I think, for academics, there a ray of hope to be found in this Ninth Circuit case. Second point, free speech is not absolute. There are categories of unprotected and less protected speech. We're all familiar with the words of the late Justice Oliver Wendell Holmes, there's no right to falsely shot fire in a crowded theater. At least since Chaplinsky versus New Hampshire in 1942, the Supreme Court has said that there are categories of speech that the government can prohibit and punish. For instance, child pornography is a category of unprotected speech. The government can not only prohibit sale and distribution, but even punish private possession. False and deceptive advertising is a category of unprotected speech. There are 3 categories of unprotected speech relevant to colleges and universities. First, incitement of illegal activity is speech unprotected by the First Amendment. Now, it's important with regard to all of these categories to draw a distinction between the legal test for when the speech can be punished as opposed to the more colloquial use of the phrase. For incitement, the legal test comes from Brandenburg versus Ohio in 1969. There, the Supreme Court said speech can be punished if there is a substantial likelihood of imminent illegal activity and if the speech is directed at causing imminent illegal activity. Imagine a speaker on campus says to an angry crowd, go commit acts of vandalism, break windows, start buildings on fire. I think in that context, the speaker would be punished for incitement. A second category of unprotected speech are called true threats. the Supreme Court has said, if speech rises to the level of a true threat, it's not protected by the First Amendment. The Supreme Court hasn't done much to clarify the definition of true threats, but my view here is there's no First Amendment right to cause a person to reasonably fear for imminent danger to his or her bodily safety. Imagine a student's walking across campus. Imagine an angry crowd surrounds that student. The crowd yells things at the student that cause the student to fear that he or she is about to be beaten. Even if no blows are struck, that speech that could be punished is a true threat. A third category of speech that's unprotected is harassment. It's familiar in the workplace context that speech that's harassment can be the basis for liability. If an employer says to an employee, "Sleep with me, you're fired," the employer would have no defense to liability to say, it was just words. Also in the employment context, it's clear that speech that creates a hostile work environment can be a basis for liability. I think in the educational context, the law is that speech that's directed at a person or speech that's so pervasive as to materially interfere with educational opportunities based on race or sex or religion or sexual orientation is not protected by the First Amendment. So I've listed the three categories of unprotected speech most relevant here: incitement, true threats, harassment. You'll notice what I didn't list as a category of unprotected speech: hate speech. I've so often been asked, what's the line between free speech and hate speech? But according to the Supreme Court, hate speech generally is protected as free speech. When the Nazis wanted to march in Skokie in the late 1970s, predominantly Jewish suburb of Chicago, with a large number of Holocaust survivors, every court to rule held that the Nazis had the right to demonstrate there. Or another example, case from 1992, RAV versus City of St. Paul. St. Paul, Minnesota adopted a law prohibiting burning a cross or painting a swastika in a manner likely to anger, alarm, or cause resentment. The Supreme Court unanimously declared that unconstitutional. In the early 1990s, over 350 college universities adopted so-called hate speech codes. Without exception, every one to be considered by a court was declared unconstitutional. In part, I think this is because of the inability to define what's hate speech, and man, that's not unduly vague or overbroad. In part, it's based on the reality that hate speech codes and hate speech laws are so often used against groups that they're meant to protect. But I think most of all, hate speech is protected in the First Amendment because it expresses an idea and a view, albeit a vile one. And all ideas and views are protected in the First Amendment. Third and final point, college and universities can have time, place, and manner restrictions with regard to speech, so long as they leave open adequate alternative places for communication. College universities can have time, place, and manner restrictions so as to prevent disruption of campus activities. A college university can say, no protest or demonstrations in or near classroom buildings when classes are in session. Colleges and universities can use time, place, and manner restrictions to prevent disruption of campus activities. I suggested to the Berkeley chancellor last summer that the most controversial speakers speak in auditoriums rather than in the open area of campus. If it's an auditorium, there can be tickets or identification required. If it's an auditorium, there can be metal detectors if necessary. If it's an auditorium, the perimeter can be secured. None of that's possible in an open area. One key open question that's unresolved is how much does a college or university have to pay so as to protect safety? When can a college or university say it just can't absorb the costs anymore, and since it can't protect security, it's going to cancel this speaker? Berkeley spent $3.9 million in September of 2017 to facilitate controversial speakers being on campus. Where is the point at which a campus can say, it just can't afford the cost? There just isn't law to this point answering the question. I've emphasized the principles of free speech with regard to student. It also applies to faculty expression. I also think campuses have a duty to work to create an inclusive learning environment for all students. It just can't be by punishing speech. I realize that there are those who disagree, who would like to see campuses do more to restrict hateful and offensive speech. I don't think it's allowed under the First Amendment. I also believe that the only way that our speech can be safe tomorrow is to protect the speech we don't like today. We don't need freedom of speech to safeguard the expression we like. We'd let that go on anyway. We need free speech to protect the speech that we detest. All of this is based on the assumption that we're better off letting all ideas and views be expressed than giving to government officials or campus officials the ability to pick and choose what messages to allow and which to prohibit. I share that faith, at least most of the time.
Thank you. That was really quite interesting. Now we have a few questions, and we thought this was a great opportunity to get your thoughts and perspectives. So this came from Professor Del Futuro. We were just emailing and chatting about several months ago. So the question here is, under what circumstances do university authorities have the legal right and or moral justification to limit the speech of faculty, staff, and students? And I know you both have sort of touched on this, but maybe you could elaborate. We'll start with Professor Del Futuro and then Dean Chemerinsky.
Yes, absolutely. Dean Chemerinsky did go through many of the legal parameters for the regulation of speech on campus. Being here as a humanist representative, I'm particularly interested in that question of moral justification. At what point does a university administration have a moral justification for limiting the speech of any of the citizens on campus? I'm choosing just one point among many. I think it's important for university officials to intervene when the speech of any entity, particularly anyone who has power, is such that it interferes with the free expression of other entities. So to give an example, on my own university campus, this was about 10 years ago, we had some overzealous residence life staff people who ran a program that was really coercive in terms of going far beyond simply describing the university's viewpoint on civility and race relations and so on, really demanding that freshman students had to attend things that should have been voluntary, but also that they adopt these views as their own. I think we need a better understanding of the reality, in addition to the things Dean Chemerinsky mentioned. The university, its staff, its faculty have a right to express opinions. They do not have a right to demand that the students share those opinions, and that is not always as well as understood as it might be. A professor can demand that a student learn the course material, let's say learn what a textbook says about evolution. The professor cannot demand that a student accept that as his or her personal view, cannot write course questions in a way that the right answer is one that comes down on a particular side in a dispute. Students themselves, when they are in large groups, when they are in powerful positions, need to be educated that their speech cannot be such that it interferes with the speech of someone else. So I would say, as one point in when should a university administration interfere with speech, it should interfere with speech when that speech itself is not only illegal in the sense that Dean Chemerinsky was talking about, but also is detrimental to the free speech of others.
Can I respond? Should I respond?
Yes, go ahead.
Okay, thank you. I agree with what Joan said. I would also draw a distinction between speech in what I would call the professional realm and speech in, let's call it, the non-professional realm. When it comes to a faculty member's teaching and scholarship, of course there has to be content-based evaluation. When a professor is coming up for tenure or promotion, there has to be an evaluation of the quality of the scholarship. When a professor is teaching, the focus is on the content of the teaching. If I ask a professor to teach contracts law, and the professor goes in every day and just talks about what's going on in NCAA basketball, or professional sports, I can say to the professor, you're not doing your job. Now, my hope would be that the evaluation of the content would not be ideological, and it would not be based on the viewpoint of the professor, but there still has to be a content-based evaluation of the quality of the work. Likewise, when professors grade student papers, it has to be on the basis of the content of the work. Once more, I would hope no student would ever be rewarded or penalized because of his or her ideology. But in the professional realm, we have to look at content. On the other hand, in the non-professional realm, I don't believe that students or faculty should be able to be punished on account of the content of their speech. If a professor chooses to go to Klan rallies on the weekend, or a professor chooses to go to a Halloween party in offensive costumes, or a student does the same kind of things, I don't think that that's a basis for the university disciplining that faculty or member or that student. I think that's why this distinction between the professional and the non-professional realm is so important.
Thank you for that. So we are going to move on to the next question here. So this question here is, under what circumstances are individuals justified in claiming that their own rights or interests justifying banning, shouting down, or penalizing someone else's speech? And I know Dean Chemerinsky had touched on this as well. So if you want to start first, and we'll have Professor Del Fattore. If you want to add anything else?
Sure. There's no First Amendment right to use speech to silence others. There was an incident at the University of Oregon this past fall where the president, Michael Schill, was going to do a State of the Campus address, and disruptors attempted to shout him down or to sing or hum so he couldn't be heard. There was an incident at William and Mary where a lawyer for the ACLU was going to come and speak after Charlottesville, and a group led by some from Black Lives Matter came and shouted so the speaker couldn't be heard. There was a very famous incident at the University of California, Irvine, a number of years ago, where the Israeli ambassador, Michael Oren, was going to speak, and 11 students in succession yelled so he could not be heard. And I've heard some say, well, they were just using speech, so they had the right to do that. I strongly disagree. The law does not support the right to use speech to silence others. This would be called a heckler's veto, and there is no First Amendment right to exercise a heckler's veto, to use speech to silence others. Otherwise, the only speech that would go on would be that which people don't care enough to shout down or silence.
Oh, Joan, I think you're on mute. Okay.
I'm off mute. Of course, I agree with everything that everyone said. Some years ago, I wrote a book called What Johnny Shouldn't Read. It was about challenges to the teaching of controversial materials such as evolution, the way people talked about religion, or did they teach about religion. One thing that struck me as I was interviewing participants in lawsuits, I was interviewing the attorneys, the parties in the lawsuits, people had a kind of missionary gleam in their eye, in some cases quite literally when we were talking about religious issues. And they justified shouting down the opposition. They justified silencing speech even when they thought it was true. But they did not want it to be promulgated because it contradicted a deeply held belief. Their justification, and to them it was very, very compelling, was there is no equivalence between truth and falsehood. So if I am representing the truth, it may be framed as God's will, it may be framed as a social standard, it may be framed as some way of looking at reality. If I am representing the truth, then the same rules do not apply to me that apply to other people. They use the term false equivalency, which is more appropriately used in other contexts, to vilify what many of us would see as an ideal, which would be just what Erwin just described, having the same rules for everyone. Whatever rules you make for other people's speech, you have to live with. I think we're not going to meaningfully address those kinds of tensions on campus until we address the underlying ideas, not only what the rules are and what has to be enforced, but where people are coming from when they do this. And it is not only students who do that. I was on a committee for some years at the University of Delaware that dealt with faculty complaints of various kinds. More than once, I had faculty who came to us to say that their right to free speech was violated, and what had occurred was a peer disagreement. That is, someone else argued with them or said that their speech was offensive or told them, I don't want to hear that. This is a peer disagreement. And yet the professor would feel my right to free speech was violated, almost as if my right to free speech includes the right to win the argument. So what I would contribute to this is, I think as we talk about these things, we need to talk both about what the end result should be, but also about what are the impediments within the interactions among individuals that are getting in the way of reaching that result.
Thank you for that response. We'll move on to this last question here. What are your thoughts on the role of social media and free speech in higher education today? Professor Del Fattore, would you like to start first?
When I saw that question, the thought that occurred to me actually was The Martian. You may know The Martian was a novel that had to be self-published because publishers said it would never go anywhere. It ended up being a bestseller. They made a movie with Matt Damon and so on. And I think that illustrates some of what's going on with social media more broadly in the culture, which is that, to state the glaringly obvious, the gatekeepers are not there anymore. People have power who didn't have power before. There's a I shouldn't say a greater emphasis, a different kind of emphasis on massive responses. How many likes do you get? How many shares do you get? How many people respond, to the point where that becomes an end in itself? I think perhaps trying to avoid the obvious things about people being able to troll faculty, that kind of thing. I think one of the considerations about how social media is used is that it changes the type of discourse. It changes the tone of the discourse. I've written, as you mentioned, I've written some articles recently, not about my academic field of free speech, but about personal essays on the choice to live single. And I notice even when editors don't change what I wrote, and they almost never do, the headlines are very sensational, whereas what I wrote was much more moderate, quiet, reasoned. But the sensational headline is necessary to get clicks, to get people to read it. So I think one of the effects of social media is that it is changing what is considered acceptable discourse or even necessary discourse. It is creating a situation in which it is expected that people will shout because otherwise it is assumed that we don't take you seriously or we don't pay attention to you.
Dean Chemerinsky?
I think that internet and social media are the most powerful tools for communication to be developed since the printing press. It used to be, in order to reach a mass audience, you had to be wealthy enough to own a newspaper or get a broadcast license. Now anyone with a smartphone, or for that matter, anyone with access to a modem in a library, can immediately reach a mass audience. Also, I think the internet and social media change things because of their permanence. It used to be if a newspaper published something defamatory, it could do great harm, but the story would be the bottom of the birdcage in a couple of days, and the only way someone would find it would be if they would go to a library and look for it on microfilm. On the other hand, now, once something's on the internet, it's there forever, and it's widely accessible to so many people. This has great benefits, but there are also costs. It's much easier now to engage in harassment of people by using social media and the internet. I'm going to be arguing a case in the Fourth Circuit next week on behalf of students at Mary Washington University who were targeted for harassment over Yik Yak. Over 700 messages, many vile, many threatening, were sent to them. And what is the obligation of a campus in the face of this? The internet and social media can be used to reveal very private information about a person. Instances of so-called doxing, where it's revealed that somebody is transgender or somebody is undocumented. And so I think that our law has only begun to deal with the technology, and it simply hasn't kept up to this point. I predict that the hardest issues that are going to come up with regard to free speech on campus in the years and decades to come will involve the internet and social media. The law up until now has often tried to draw a distinction between speech on campus and speech off campus. The internet and social media make that irrelevant.
Thank you for that. We are about to run out of time here, but we do have one question, very short. How does an educational institution reconcile freedom for the thoughts of an employee may hate and the responsibility of the university to monitor and supervise their employees? Don't know if that gives you some ways to respond. So the context is there's been a couple of incidents involving university or high school employees who have been recorded making overly racist remarks, telling XYZ people to go back to where they came from. So how do we reconcile with that?
If speech is protected by the First Amendment, then obviously a university can't punish or discipline for it. But it's important to keep in mind there are things that a university can do without punishing or disciplining speech. Universities and university officials have their own speech rights. Campus officials can and should condemn hateful speech. Also, campuses can do other things without restricting speech to be protective of students and faculty. There is a point, though, at which speech is unprotected by the First Amendment. It may be, as Jones said, because of Garcetti versus Sabalas, that says there's no First Amendment protection for speech on the job and scope of duties. It may be because the speech rises to the level of a true threat or harassment. If the speech is unprotected by the First Amendment, say because it meets the test for harassment, then a campus can punish such speech, and a campus might be liable under Title IX or Title VI for not taking actions against the speech.
I would say very much the same thing. I think that's a really good question because it's a very, very difficult point. When someone's expressing views, is the way I would interpret that question, someone is expressing views that lead, let's say, students or coworkers to feel as if they themselves might in fact be discriminated against by this individual. There is clearly a line between what the individual says they believe and how they behave. If an individual cannot be shown to have done anything discriminatory, it's a very different story if all they're doing is speaking. But nonetheless, it's a situation where I think education has to be the key. There needs to be a clear understanding of what is the difference between someone expressing a protected opinion and someone expressing an opinion that legitimately rises to the level of what someone could reasonably consider a threat.
Thank you. I want to really thank all of you for being here and attending the webinar, and thank you to our three distinguished speakers for their thoughts and ideas and expertise. And again, I think we are running out of time, so thank you all for coming. Enjoy the rest of your day wherever you are, and the recording will be sent to you in a bit shortly. Thank you.